Hello YouTube, I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users getting folks the answers they need from an employment attorney. We have here today a question from YouTube user Mr. D, who says to us, and we're not going to extrapolate what that username means. Mr. D says to us, "Hey Vince, I was wondering if you could do a quick video on how in-house counsel for big corporations work. Like different levels, and how or who ultimately is the decision maker. I am pro se and dealing with a huge corporation that has everything in-house, including employment defense attorneys. But I'm dealing with general counsel now, and he's asking me to expunge some evidence I have saying it was sent to me by accident, and that it is actually covered by attorney-client privilege. But it's also evidence that directly contradicts their position statement and basically proves my case. Is that legal? Because the cat's out of the bag, so to speak. Thanks in advance. Sunglass, 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 triple emoji." All right. So, first things first. If we'll get into a long talk about in-house counsel structure. They meandering and extensive because different companies have different structures, and I can't know them all, but I'm familiar with many of them. But more importantly, if some defense attorney commits some kind of breach, some kind of mistake, some kind of perhaps malpractice, or breaches their attorney-client privilege, and you are pro se and they ask you to delete what they sent you, do not delete that. Do not delete that at all, especially if it's useful to your case. Now, they're free to make a motion. They can ask the judge to have you delete it. By all means. Listen. And if the judge or the arbitrator, administrative law judge, whoever it is, if they order you to do something with that evidence, you must comply. You must do it. Yes, I fully agree with that. But don't do things because your enemy asks you to. Now, and I've heard this argument a bunch of times, where attorneys will say, "Oh, well, we must be courteous to our peers, our fellow attorneys." Yeah, courteous, polite. Yes, I agree with that statement. And as part of that courtesy, we must do things like when they mistakenly send us evidence that furthers our case and harms their case, that amounts to a malpractice level breach of their attorney-client privilege, we must delete that evidence. No, that's not said anywhere. There's nowhere in the attorney rules of conduct that says when opposing counsel F's up, your duty is to help opposing counsel. My read, if I remember my ethics coursework, is that my duty is to my client. I have a duty of loyalty to my client. Is opposing counsel my client? Does opposing counsel put the roof over my head? No. I mean, sort of, because opposing counsel is going to cut the check. But the reason I have a case in the first place is because I have a client. And everything good in my life that I've ever had, and I have far more than I deserve, but everything good in my life that I'll ever have came as a result of helping a client. So the ethical duty is to the client, as is clearly recorded in the ethical standards. And there's a duty of courtesy to opposing counsel, but a duty of loyalty and care to the client. Well, I guess my read is, if opposing counsel asks you to go ahead and delete some evidence that helps your case and hurts his client's case because he or she mistakenly sent that to you, you should courteously say, "I'm so sorry, Steve. Steve, I'm so sorry. You know I can't do that. My duty is to my client." And you have now complied with both of your duties. You have been courteous. And you should be courteous. This is the law. This is a civilized endeavor. We are not animals. We must be courteous. And I agree that we must comply with that duty of courtesy. But I also believe, in my heart of hearts, that we have an affirmative duty to be loyal and show a duty of care to our clients. And that's not going to include destroying evidence or deleting evidence that helps my clients. Listen, you're free to make a motion, Steve. If you want to make a motion that I shouldn't be able to use this, Steve, I'll appear at that motion date. I will oppose it strenuously. And I'll probably suggest, because it's my job to suggest, because I must help my client, I'll probably suggest that perhaps now your client has a malpractice claim against you, and I'm doing that to drive a wedge between you and your client, to break down that trust you've built up. That's not entirely courteous. That's not a nice thing to do. But that also favors my client. That's going to drive that wedge and help my client, and, well, if I have to choose between being entirely courteous and my client's best interests, guess what? I want to help my client. And even if I was a monster, perhaps I am, but even if I was a monster, and even if I hated my client, which I do not, all good things in my life come from my clients. They are, as far as I'm concerned, the sun, the moon, and the stars. They do more for me than anyone I've ever cared about. Jokes. My clients have done more for me than you could say my family has. Kidding. But they are the sun, the moon, and stars. To me, they are the guiding light. They have given me everything I have, and I have more than I deserve. I've been very fortunate. So, yeah, Steve, hypothetical defense attorney, I'm going to drive that wedge. And I'm going to be like, well, the good thing for your client here, Steve, is that now they can just sue you for whatever they end up paying us. So they're basically off the hook, because listen, if we win $1 million, they can just come after you for the $1 million. Is that entirely true? Maybe not. I'm not up on malpractice, but that's my understanding of how malpractice works. It's my sincere understanding of how malpractice works. And I'm going to go down swinging, opposing you, under this theory that we need to get rid of some evidence that you mistakenly sent us. Also, my understanding of attorney-client privilege is that once it's been breached, it disappears. There's more to it than that. It's a complex set of arguments, right, as to when attorney-client privilege does and does not exist. But if you breach it, generally speaking, it's over for this piece of whatever you breached it about, right? Like, it's why we have to notify our clients when they bring in third parties to meetings. Like, hey, there's a third party here, and that party is not my client, so we do not have attorney-client privilege in this meeting. You know that, Steve. Hypothetical defense attorney Steve. You know that. So when you breached it, this attorney-client privilege that you're seeking to enforce, well, it disappeared. It stopped existing. It sounds like you're trying to enforce something that doesn't exist. To which I would say to you, I wish you luck. And I will urge your client to sue you for malpractice, and I know that's not going to come out of your pocket. Save you malpractice insurance. And so I don't feel that bad about it. And I'll be courteous to you, Steve, and I'm going to buy you a drink later at the bar, because I feel super bad about suggesting your client no longer has quite the liability they used to have, because now they can just sue you for malpractice. And I would listen, obviously I'm trying to be a little bit humorous here, but like, Mr. D, the idea that you would destroy that evidence, you would delete that evidence for them, yeah, that's not going to happen. That's not going to happen on my watch. Like, nah. And I can tell you right now, if I had an associate who received a request from opposing counsel to delete some beneficial evidence, that associate was working here, and that associate was like, well, listen, I know Steve, the hypothetical defense attorney, Steve and I are tight, so I got to do right by Steve. Well, you made your choice, associate. You chose professional courtesy over your very real ethical duty to your clients. And you chose your friendship with Steve over our firm. Is Steve going to pay you 6 figures? Is Steve going to put a roof over your head? Is Steve going to support you when your license is in peril because you turned on your client? Is Steve's that good of a guy? Steve's one hell of a guy. Steve's got a new dependent. His name is Young. Well, I just got a little riled up there. Steve's new dependent is Young Associate. Hypothetically, Young Associate who did what Steve asked. Right? You're not working here anymore. I'll tell you that right now. That ship has sailed. Oh, you don't care about your clients? Good. Get fucked. Get out of here. We don't need you. You're not. Nobody's that talented. Right? Like, Priorities. Priorities. Fascinating. Fascinating that defense counsel would ask you to do that. And listen, different jurisdictions have different ethical requirements, so maybe things are different where you are. I don't know, but I suspect they're not in this respect. Check with local counsel, always, about the ethical guidelines, but also, not for nothing, you're not an attorney, you're pro se, so you're not actually subject to those ethical guidelines because you don't have a license. You haven't signed off on, agreed to uphold those ethical guidelines. You're just a person trying to get made whole for what was done to you. And they could say you have these ethics requirements, but people say a lot of things. New York State says my ethical requirement is I have to be polite to people when they scream at me. New York State says I can't be cruel during mediation. I can't embarrass people. I don't see the part of the ethics guidelines where that's said. I've never really been aware of that, right? That's not there. But they decided it's there. But they weren't the ones who got to write those laws. Fascinating, right? They're imagining these additional rules, these additional ethical guidelines that are created by people who were never elected. Clearly disinterested. Yeah. Oh, you think I should have additional guidelines? And those guidelines, perhaps, are to the detriment of my clients. That's fascinating. Let me know how that works out for you. I'm going to go ahead and just ignore the fuck out of those. That's not real. That's you being an asshole, thinking you have power you don't have. Right? Like, I'm going to go hard in the paint at mediation. Feel free to take issue with it if you like. But if it serves my client's interests, well then, guess what? Guess what we're doing, right? Just giving you my perspective on deleting that evidence, right? Now, you know what? It's already a 12-minute video. I'm going to go ahead and make you a separate video on in-house counsel structures, okay? If this was helpful, like, subscribe, comment down below, share our channel so it can grow. Thank you, and take care.